Tension explodes. BC Conservative leader John Rustad addresses private land controversy. A landmark BC Supreme Court ruling has sparked intense debate across the province, drawing attention from homeowners, Indigenous communities, and policymakers. On August 7, 2025, Justice Barbara Young recognized Aboriginal title over roughly 800 acres in Richmond, including industrial zones along the Fraser River. This decision invalidates fee simple titles previously held by Canada and the City of Richmond, potentially giving the Cowichan tribes significant control over the land. It also affirms First Nations' constitutional right to fish for food, emphasizing the importance of cultural and subsistence practices. Experts call this a pivotal moment in balancing historical Indigenous claims with the protection of existing property investments. The ruling has sent shockwaves through British Columbia, causing concern among homeowners and investors over potential impacts on property values and future development. While Indigenous leaders celebrate a step toward reconciliation, property owners worry about uncertainty in real estate markets. By suggesting that Aboriginal title and private ownership could coexist, the court has created a legal landscape where property rights may be challenged. Lawyers caution that this precedent could encourage other Indigenous groups to assert claims on privately held lands, risking long-term effects on economic planning, retirement savings, and generational wealth. John Rustad, leader of the BC Conservative Party, has strongly opposed the ruling, calling it a direct assault on private property rights. He argues that private land ownership underpins economic stability and public confidence in governance. Rustad warns the precedent may trigger legal disputes and limit property use or sales, deterring investment in housing, industry, and resources. His response includes advocating for repeal of the Declaration on the Rights of Indigenous Peoples Act, DRIPA, which enshrines UNDRIP into provincial law. He asserts DRIPA gives Indigenous claims undue legal precedence, complicating property rights and the province's economic future. Legal experts note that while the ruling does not immediately displace private landowners, it sets a precedent that could affect future disputes. Recognizing Aboriginal title over lands currently held in fee simple raises questions about taxation, resource use, and development. Urban areas may face heightened tensions as developers and property owners navigate uncertainty over potential Indigenous claims. Future sales could be delayed or complicated, creating ripple effects on local economies and discouraging investment. Homeowners worry not only about current impacts but also long-term concerns like inheritance, retirement planning, and family wealth security. Indigenous leaders view the ruling as a historic affirmation of their enduring connection to the land. For the Cowichan tribes, it validates centuries of cultural stewardship, traditional practices, and community ties to Richmond. Tribal representatives emphasize collaboration, aiming to have their rights recognized while considering concerns of other land users and municipal authorities. Advocates argue that reconciliation requires tangible acknowledgement of land rights, and the court's decision is a key step toward addressing historical injustices, especially in areas affected by industrial development. The BC NDP government has announced plans to appeal the ruling, citing the need for legal clarity. Premier David Eby stressed the importance of upholding Indigenous rights while protecting the interests of all British Columbians. The government faces the challenge of balancing legal, cultural, and economic concerns, ensuring reconciliation does not destabilize private property or development. The appeal will likely influence broader legal interpretations of Aboriginal title and shape future policy in areas like resource management, urban planning, and commercial development. As the legal dispute unfolds, British Columbians face a central question about coexistence. The tension between Indigenous rights and private property is tangible, intersecting legal, social, and economic concerns. Observers wonder if these interests can be reconciled or if prolonged conflict will affect provincial stability. The outcome will influence Richmond residents and the broader direction of property law and Indigenous relations across BC, shaping policy and community dynamics for years. In response, the BC Conservative Party has stepped up efforts to support property owners and investors. Rustad and his team are organizing grassroots campaigns, promoting public engagement, and raising awareness. The party calls for policy reforms that clarify property rights while recognizing Indigenous claims within a structured framework. By encouraging dialogue and mobilizing citizens, Rustad seeks to pressure the government to ensure fairness, predictability, and balance in handling land disputes. The debate over Aboriginal title goes beyond individual properties, touching identity, culture, and social justice. Policymakers, community leaders, and the public must confront historical inequities while considering practical impacts on daily life, urban planning, and investment. Governance, equity, and the rule of law remain central as both Indigenous communities and property owners navigate this evolving legal landscape. The ruling highlights provincial values like fairness, transparency, and coexistence. Politically, the ruling highlights tension between reconciliation and governance. Leaders must respect Indigenous cultural claims while considering economic impacts on housing, industry, and businesses. Balancing reconciliation with property rights requires nuanced policies addressing multiple stakeholders. Failure could create social friction, reduce investor confidence, and challenge long-term economic planning in BC. For affected homeowners, the decision creates uncertainty over property use, sale, and value. Families with generational investments in Richmond face potential legal disputes affecting inheritance and retirement plans. The psychological and financial stress underscores the need for clear political leadership and legal guidance to protect both Indigenous rights and private property. The debate over Aboriginal title and private property remains unresolved. Policymakers, Indigenous leaders, property owners, and legal experts must engage constructively to establish equitable guidelines that prevent conflict while respecting historical claims. Through collaboration, transparency, and safeguarding rights, BC can create a practical and just model of reconciliation, setting an example for other provinces. In conclusion, the BC Supreme Court ruling has intensified debate over Indigenous land rights and private property, celebrating Indigenous milestones while raising concerns for homeowners, investors, and leaders. As the appeal unfolds, balancing Indigenous rights with property protection is crucial for stability, investment, and reconciliation. The outcome will shape BC's land law and Indigenous relations for generations, marking a defining moment in the province's history.